Hello everyone, I'm Anuj Jaggi and I'm a legal intern with LEXIS and Company, and the topic for today's video presentation is retrenchment. So, until 1953, there was no statutory provision to immunize the workmen from the hazards of involuntary unemployment. So therefore, there were many protective measures which were enacted in 1953 defining retrenchment and stipulating for the payment of compensation as a condition to provide a valid agreement or for a precedent for a valid retrenchment. Basically, retrenchment is the termination of worker due to any bona fide reason of employer other than by way of punishment. Further, retrenchment is ordinarily resorted to in continuing business. Chapter 9 and 10 of the Code provides for retrenchment. Chapter 9 is applicable in those industrial establishments employing more than 50 workers. And further, Chapter 10 is applicable only when there are more than 300 workers working in the industry. Further moving ahead, Section 2, Clause ZH of the Industrial Dispute Act defines retrenchment, which means the termination by the employer of the service of a worker for any reason whatsoever otherwise than as a punishment inflicted by way of disciplinary action. But ultimately, it does not include various elements like voluntary retirement of the worker or reaching a certain age, or termination of the service of a worker on the ground of continued ill health, and termination of service of the worker as a result of completion of the term of the contract. These are the some conditions under which retrenchment, it is not a retrenchment. Further, no worker employed in any industry who has been in continuous service for not less than 1 year under an employer shall be retrenched by the employer until and unless the worker has been given 1 month's notice in writing. Further, the worker has been paid on time of the retrenchment. And lastly, notice in such manner should be prescribed on the appropriate government or such authority as may be specified by the appropriate government. Further, Section 71 talks about procedure for retrenchment, where any worker in any industrial establishment who is a citizen of India is to be retrenched and he belongs to a particular category of a worker is that establishment, then in the absence of any agreement between the employer and the worker or the employee, the employer shall ordinarily retrench the worker who was the last person to be employed in that particular category, unless for reasons to be recorded by the employer when he retrenches any other worker. Further, for retrenchment under Chapter 10, the following conditions, which are quite important, are applicable. Section 79, Clause 1 of Industrial Dispute Act talks about that no worker employed in any industrial establishment to which the Chapter 10 applies has been in continuous service for not less than 1 year. The various conditions under this section are the worker has been given 3 months prior notice in writing indicating the reasons for retrenchment and the period of notice has expired. The prior permission of the appropriate government has been obtained on an application made on this particular behalf. Second, an application for permission under subsection 1 shall be made by the employer electronically or otherwise in the prescribed manner, stating clearly the reasons for retrenchment, and a copy of such application shall also be served simultaneously on the workers concerned in such manner as may be prescribed. And the third condition is where an application for permission under subsection 1 has been already made to the appropriate government after making such an inquiry and it thinks fit and after giving a reasonable opportunity of being heard by the employer. And lastly, where no application for permission under subsection 1 is made, the permission for any retrenchment has been refused. Such retrenchment shall be deemed to be illegal from the date on which the notice of retrenchment has been served. So, lastly, the last topic under this is section 74, which is the closure, or it states about 60 days notice to be given of intention to close down any undertaking. And that was it for retrenchment. So thank you for listening, and if you have any kind of question, please ask them in the comment section. Thank you.